Hello, everyone. Welcome. My name is Kambiz Ranawati, board member for ColumbiaDC and a graduate of the School of Engineering and Applied Science. First, let me thank our partners for this event, MIT and the Yale Club of Washington, D.C., and the members for being with us this evening. Very honored to have Katherine Franke James L. Dohr Professor of Law at Columbia Law School to talk about Roe v. Wade, the history, the recent majority opinion from SCOTUS, and what the future holds for us in this matter. Please allow me to briefly introduce our speaker, but I would encourage everyone to check our website for her full bio. Katherine Franke is the James L. Dohr Professor of Law at Columbia University and Director of the Center for Gender and Sexuality Law. She's also on the executive committee of Columbia's Institute for Research on Women, Gender, and Sexuality, and the Center for Palestine Studies. Professor Franke is the founder and faculty director of the Law, Rights, and Religion Project, a think tank based at Columbia Law School that develops policy and thought leadership on the complex ways in which religious liberty rights interact with other fundamental rights. In 2021, Professor Franke launched the ERA project to develop academically rigorous research, policy papers, expert guidance, and a strategic leadership on the Equal Rights Amendment to the US Constitution and on the role of the ERA in advancing the larger cause of gender-based justice. Professor Franke, the floor is yours.
Thank you so much, Kambiz, and thank you to the Yale Club of Washington, D.C. for inviting me back. It was my great pleasure to speak with you some months ago about other work, but the events of the last couple of weeks call us again to consider the role of law and the Supreme Court in our political life. In this last week, we were shocked, I think across the political spectrum, by the release of a draft opinion from the Supreme Court. This is a highly unusual moment or event to have a Supreme Court opinion released unofficially, to be sure, before their final opinion, which we expected would be released in late June. It's not the first time that a draft opinion or information about the deliberations of the justices have been leaked prior to the issuance of a final opinion. But I will say it is the first time this has happened since the invention of the internet. And so having that opinion circulate as it has through Politico, which released it, and then just take fire across the internet, I think gives different meaning to this kind of leak than we've ever seen it before. So a few questions before we talk a little bit about what's in this draft opinion, and I will urge you to remember it is a draft, and we'll come back at the end to some thoughts about what we might expect to see in the final opinion based on the leak. But the first question is, who might have leaked it? And we don't know. We may never know. The Supreme Court may have an interest in not actually having it become public about who leaked it, because it could have been one of the justices themselves. It also could have been a clerk working for the justice, one of the justices. It could have been one of the many other people that work in that building, from other lawyers to administrative staff to janitors to a whole range of people who go in and out of the Supreme Court building and might have found this draft sitting on a Xerox machine. We just don't know. And as I said, we may never know who leaked it. But additional question is, why would they do it? If you're a clerk working for the Supreme Court and you were found out to have leaked a Supreme Court opinion, in a case as momentous as this, you could really kiss your legal career goodbye. It would certainly get out through informal channels, if not formal channels, that you were the person who violated this very strong standard within the Supreme Court to keep their deliberations private. But it could have been someone who favored the opinion and where it came out and its reasoning, and it could have easily been someone who did not. In the pundits thinking about it, those who disfavored the outcome of the draft opinion or its reasoning could have taken the view that provoking public outrage about Justice Alito's reasoning and where the court ends up would be effective in perhaps changing the court's final opinion. You know, Chief Justice Roberts sees himself, and I think rightly, as the custodian of the US Supreme Court's public reputation, a reputation that it cultivates and is constitutionally required to be a body that stands in a way outside of politics. Their job is to interpret the Constitution as an enduring document that doesn't mean different things at different times, given the political composition either of the Congress or of the people or of the court itself. So what privacy means, what liberty means, what the Constitution means is something that should be a consistent value and legal norm across time. And so for the idea that that this opinion was so political in its being leaked in draft form, and the kind of opinion that Justice Alito has written, which I believe is so political, is something that I think Chief Justice Roberts, one would imagine, would have wanted to avoid. And it's possible that if you don't agree with the opinion, you might have seen a play whereby Chief Justice Roberts would step in to try to, you know, staunch the bleeding here and try to repair the court's reputation, because it had already been politicized by some of the recent nominations and confirmation hearings and things that were revealed through that process, through the failure to approve Merrick Garland or confirm Merrick Garland as the last Barack Obama presidency nominee to the Supreme Court. And the court itself had been quite politicized in recent years. And Chief Justice Roberts really sees his job as to try to dial back the tone and the public opinion, a widely held public opinion that the court has become too politicized. So he might have done that by garnering a different majority, or at least a toned down opinion, having seen what happened with the release of this draft. That's one view. You know, another is, if you support where the outcome is, better to get it out now and then lock in those 5 votes for this view, because if anybody changes their position, it would be regarded as them responding to public opinion and to public outrage, which is something I think most justices would want to avoid. So there could have been a concern that there maybe was some weakness in this 5-member majority. Some people were ambivalent about staying in with the Alito opinion, and this might have been a way to hold them in that majority, and or prepare the public for the bomb that was going to land in late June, and thereby make the dropping of this opinion actually something that kind of happened over a period of time rather than all at once. So, you know, there are other views on why someone might have leaked this opinion, and we may never know also why. So it's important to note, again, that this is a draft. It's dated February 10th. So having been leaked in April, this may not even be the most recent version of the opinion that was circulating among the justices. It said at the top that it was the first draft. In cases like this, there are many drafts of opinions that the Supreme Court members circulate amongst each other, while they're also writing concurrences and dissents. And then the majority opinion is responding to those concurrences and dissents. And so it's very likely that the draft opinion we saw was actually not the opinion that the court was working with at the point when it was leaked. But again, how that leak will affect what the final opinion looks like, I think is very difficult to say. But I will say that this is really the first time in the history of the Supreme Court that the American people are playing an inadvertent role in the editing of a Supreme Court opinion. Usually it's just 9 people and their clerks, but 9 people in conversation, in debate with one another, the members of the court going back and forth that are the only ones charged with editing a draft and then final opinion. But we're all doing it now. And then indeed this webinar is part of that as well. And I do want to say I look forward to your questions. We'll save plenty of time for those questions, and we'll ask you to drop them into the Q&A function down at the bottom of your screen, and I'll do my best to answer them carefully and sensitively, and to get to all of them if I can. So just a little bit of background for those of you who are not reproductive rights lawyers or lawyers at all. Roe versus Wade was decided in 1973. You know, it was a while ago, and it was the culmination of what had been a growing trend nationally in favor of the decriminalization of abortion. It was seen at the time really largely as a public health issue, because so many pregnant people, largely women, were having serious injuries, if not suffering death, from illegal and unsafe abortions. And so the issue was largely framed in the public discussion of the issue, in a lot of the briefing in the Roe case, as a matter of women's public health, more than what some others might have urged as a matter of women's equality. It certainly came up in those terms in other sectors. But I would urge you to listen to a recent podcast that Nina Totenberg has done on the sort of lead up to Roe, which I think the Daily has done, which is really quite good in sort of setting that, resetting our memory of what the conversation was at the time that Roe was decided. Justice Blackmun in Roe versus Wade begins with saying, our task, of course, is to resolve the issue by constitutional measurement, free of emotion and predilection. Right? He's wanting to decide this as a matter of rational constitutional interpretation, not as a matter of morality, of religion, and other deeply held values in society, but we have to step back and think about this issue not emotionally, but principally. And what he does is he borrows from a framework that is suggested by the American Medical Association in their amicus brief in the Roe case, and imposes this idea of trimesters, that actually abortion can be regulated in different ways depending upon how far into the pregnancy the abortion is being considered, or the idea of terminating the pregnancy is being considered. So in the first trimester, Roe holds, states cannot prohibit, criminalize, and regulate really in an oppressive way abortion in any way. We have a right to abortion in that first trimester. That changes in the second trimester, where governments could require reasonable health regulations. And here, what Justice Blackmun is referencing is this growing concept of viability of the fetus. And as the fetus reaches the point of viability, the state's interest in looking after that fetus increases. So in the first trimester, the state has no interest in protecting future life or fetal life. In the second trimester, somewhat. And in the third trimester, much more. And so in that third trimester, the court says in Roe that abortions could be prohibited entirely so long as they contain exceptions that are necessary to save the life and to protect the health of the pregnant person. Right? And so this trimester framework is the governing framework around this issue around abortion until the Supreme Court decides another case, Casey, in 2013, which I'll come back to in a moment. But what's important to kind of contextualize as this decision drops, evangelical Christians were agnostic, if not supportive, of a right to abortion. It's not that there was an immediate faith-based religious backlash against abortion, not at all. In fact, the Southern Baptist Convention had passed a resolution supporting abortion rights in 1971. They termed it a reasonable and responsible personal decision that should be left to the individual. They reaffirmed that resolution in 1974 after Roe versus Wade was issued. So these are evangelical Protestants in the United States who kind of viewed the opposition to abortion as a Catholic issue. but not one that concerned them and the morality that their religious traditions or practices really were concerned with. It's faith-based opposition among evangelical Protestants that emerged a bit later in the latter part of the 1970s as part of a larger political effort to deny Jimmy Carter a second term. So conservative Republicans, but conservative operatives had been for many years trying to mobilize both elites on the right, but also their base with an enduring appeal to racism, right? And to defending racially segregated schools. 1970, President Nixon has the IRS issue a ruling that racially segregated schools can no longer enjoy their tax-exempt status under the Internal Revenue Code because they were racially discriminatory, right? This, of course, outraged many folks in the South who had set up private schools that were racially segregated and sought and received a tax-exempt status for those schools as a kind of haven from Brown versus Board of Education and the desegregation mandate there. The problem with this strategy to motivate the right, the racist right, is that it appealed mostly to elites, but it didn't really mobilize this newly emerging evangelical right. And so Paul Weyrich, who you probably remember, many of you might remember, who was one of the founders later of the Heritage Foundation, he was looking around for a new issue of morality besides racism that could motivate not only the elites, but the base on the right, and who they could motivate to vote and defeat Jimmy Carter for a second term. So racism wasn't working the way it had in the good old days. So they pivoted to abortion, and they tested it in 77 and 78, and they were seeing that actually it was mobilizing to vote an evangelical base that they very successfully mobilized in 79 to vote for Reagan and successfully denied Jimmy Carter a second term. So since then, religion, morality, and religious liberty have really been the dominant form of backlash and resistance to Roe versus Wade, but it wasn't true at first. And it wasn't true immediately after Roe was decided. And it was really opportunistically seized on by the right as something that would have political legs, if you will, more than something that was essential to scripture, more than something that was essential to these faith-based traditions. And indeed, a lot of the work that we're doing at Columbia right now at the Law, Rights, and Religion Project is to draw from other religious traditions that actually do have very clear support for access to abortion, for a pregnant person's capacity to make that decision, counseling by rabbis, ministers, imams, and others for pregnant people in terms of getting them to the place where they feel, based on their faith, that an abortion is the right thing for them to do. So there are many religious positions on abortion and on reproductive rights, just as there are many religious positions or faith-based traditions that have views on homosexuality and other hot button issues. But what we saw in the late 70s is that this issue on the religious right, on the evangelical right, was something that was invented and mobilized quite successfully to undermine Roe. So what happened after that period in the 1980s and 90s was a series of lawsuits that were brought across the country, and a series of statutes that were passed by state legislatures across the country to undermine and chip away against Roe, against the ruling in Roe. I mean, one of the first lawsuits that followed Roe that made its way to the Supreme Court that dealt with reproductive rights was a case that made the claim that poor women or low-income women should have a right to access to payment, public payments, welfare payments, Medicaid payments for abortion. And the Supreme Court said, absolutely not. If the federal government does not want to pay for abortion, that doesn't violate the right that was secured in Roe. All you had secured in the Roe versus Wade decision was the right not to have abortion criminalized.
you didn't have a right to actually be able to exercise that right through the economic means to do so. So that's a secular objection there that was underwritten by a lot of religious briefing on the case. But what we see in these other statutes and other federal regulations during the Reagan era and other conservative administrations is this idea that we could regulate, notwithstanding Roe's trimester structure, we could impose enormous kinds of regulations on abortion that made it almost impossible for many people to get access to it. So this culminates in the Casey, Pennsylvania decision from 2013, where the Supreme Court actually changed the standard that had protected access to abortion that had been secured in Roe. And they said, actually, we're not so sure about the trimester format anymore. What we're now going to use is a constitutional standard of an undue burden. So do all of these regulations, whether it's requiring waiting periods, paternal consent, having to look at a sonogram of your fetus, being told about fetal pain. The opponents of abortion were very creative in the legislation that they passed that created speed bumps in the access to abortion. The Supreme Court said what we need to do is ask whether those regulations impose an undue burden on the rights secured in Roe. And for the most part, many of them were held not to impose an undue burden. And I raise this only to say that with Roe versus Wade being overruled in June, which is likely, it's not that it will occasion a radical practical change. For most people in this country, they do not now have a meaningful access to abortion, particularly low-income women and women of color. Right? There is one clinic in Texas that provides abortions today, Whole Women's Health. There is one clinic in Mississippi that will provide abortions along with the whole range of reproductive health care. There's no such thing as an abortion clinic. These are all clinics that provide a whole range of reproductive health care, including abortion. There's only one in Mississippi, that Jackson Women's Health Organization that includes abortion in the care that they provide to pregnant people. So if and when Roe is overruled, it will be a momentous event in so many ways as a constitutional matter, but as a practical matter, it will solidify what has been a trend, certainly since Roe was issued to begin with. So Casey, an important decision from 2013, followed then, interestingly, by Obergefell. In 2015, the Supreme Court's decision that said that it was unconstitutional to deny same-sex couples the right to marry. And one of the things that the court, Justice Kennedy ruling in Obergefell did is draw from these reproductive rights cases and from Casey in particular, and used what I call the sweet mysteries of life language from Casey, where Justice Kennedy had said, at the heart of liberty is the right to define one's own concept of existence, of meaning, of the universe, and of the mysteries of human life. I always feel like we should cue the violins right now for that language. So that was part of what was the container, the constitutional norm that held a right to make a decision about whether to terminate a pregnancy. And it also then became the container or the constitutional norm that protected the right for same-sex couples to marry as a constitutional matter 2 years later in 2015. So here we are today with many states in the South and Midwest having passed laws that quite clearly violate Casey, quite clearly violate Roe versus Wade. And the whole point of that was to tee up a case that finally the Supreme Court would take that would give them the opportunity to overrule Roe and Casey for that matter. It's important to recognize that the Supreme Court by its own rules should not have taken Dobbs, the case that we're now talking about. There was no conflict between the abortion right and the lower court had ruled correctly in this case that the Mississippi law
banning abortions after 15 weeks violated Roe versus Wade. That could have just sat on the books. So too, there was no conflict in the circuits around statutes like this. The court was looking for a decision once it had a 5-member majority with Amy Coney Barrett and her cohort now on the Supreme Court to reach this decision or to revisit Roe. So let's talk about the draft. One of the primary things that Justice Alito says in setting up what will be the reasoning about why Roe versus Wade and Casey should be overruled is that Roe was egregiously wrongly decided the day it was issued. And this is his term, egregiously wrong. This is a new constitutional term. We've never heard this term before. There is a notion in the court's jurisprudence of stare decisis, which is that once an issue is decided, the court will follow and uphold that issue in subsequent cases in terms of precedent being binding on the future. The court has set up rules for when they might overrule a previous decision, but this idea of egregiously wrong is something new. But it's almost as if he's banging the table. Roe was egregiously wrong the day it was decided. The second thing he does in arguing why Roe was wrong is to say that the trimester system makes no sense. That the trimester system is something that should be abandoned. He says it made no sense at the time and it makes no sense today. He said it's something that the court made up in Roe, and he actually even says this elaborate schedule was the court's own brainchild. I mean, to use the term brainchild in a reproductive rights case in order to undermine what is one of the most fundamental reproductive rights is itself kind of ironic. But again, this is not true. It's not something the court just made up. It was something that was suggested by obstetricians and gynecologists and the medical community in their amicus briefs. So, but that doesn't make it into Alito's reasoning. So the second move he makes is to say that there is no textual basis in the Constitution for abortion or the right to abortion or for privacy rights. That is true. The word privacy and the word abortion do not appear in the Constitution, nor do the words automobile, internet, electricity. I mean, there are all sorts of things that are part of modern life that do not appear in the Constitution because it is written on a level of generality that is designed to be able to anticipate things that come in the future, both things that haven't been invented yet, like the internet, but also the Constitution is an evolving document that should be able to keep pace with how society has changed since the mid to late 18th century, right? So this argument about abortion not appearing in the text of the Constitution is something we've seen from Justice Gorsuch also. In his concurring opinion in one of the COVID cases 2 summers ago. And he there was noting that some of the rights to bodily integrity that people would have in objecting to vaccinations, but other kinds of rights have no textual basis in the Constitution, and it was quite clear when he was making that argument that he was anticipating the abortion right later. So both Justice Alito and Justice Kavanaugh, and I would say Justice Gorsuch, have leaned on this textual reading quite clearly. And part of where they've made great use of this argument is in the religious liberty cases, because of course the First Amendment contains very explicit protections for religious liberty. And the court has said, and Gorsuch in particular in the COVID cases, that religious liberty has textual protection in the Constitution, whereas all these other things are squishy, and those are sort of second-tier rights. And in reading the arc of these cases, it's been my view that what we're really seeing emerging out of this court is a way of interpreting the Constitution that is novel
to the extent that they are tiering constitutional rights. Those rights which are explicitly mentioned in the Constitution get the highest level of protection from the Supreme Court. Those which are unenumerated, we would say, that lie in the interstices of the Constitution, that kind of lie in the concept of freedom, of liberty, of equality, of due process, etc., those are going to be second tier rights that the court might recognize if there's no conflicting value or there isn't another strong argument on the other side. So you see the court giving enormous deference to religious liberty rights in these last two terms with this new conservative majority. I think we'll see the same thing with the Second Amendment case that the court also has this term that we'll probably get an opinion in the next month. We must get an opinion in the next month. You know, the Second Amendment explicitly mentioned, you know, a well-armed militia, and they will see that as textual protections for gun rights. But racial equality, the rights of LGBT people, sex-based equality, reproductive rights, other forms of privacy, those are really second-tier rights, and we see that very much in evidence in this draft Dobbs opinion. So it's this textual argument he leans in on quite a bit, and then he moves next to the idea of substantive due process, which has been the kind of catch basin for rights for the Supreme Court, fundamental rights for the Supreme Court for a generation or two, where those rights were not specifically mentioned, but they were essential to what it means to live in a free society. So lots of liberty rights, privacy rights get their hook in the notion of substantive due process. And the case that the court relies on a lot in understanding what substantive due process means is a case called Glucksberg, in which the court said, we really need to look to history and tradition to see if the right that's at stake here is essential to or implicit in the idea of ordered liberty in our political system, our constitutional system. So is there a kind of gestalt, if you will, of ordered liberty that necessarily has to include this, like the government can't break into your house and engage in all sorts of invasive activities under substantive due process, even if it's not close to or attended to a criminal prosecution, which might make it protected by other parts of the Constitution. So in order to decide, is the abortion right implicit in the concept of ordered liberty, Justice Alito begins in the 13th century. He starts with a legal scholar, a writer of legal treatises, Henry de Bracton. And if you watch Saturday Night Live, you will have seen last Saturday, the folks at Saturday Night Live do a cold opening with using Henry de Bracton and 13th century notions of privacy, of religious liberty, and individual autonomy. So I need to read to you what Justice Scalia, that's an interesting slip. Justice Alito quotes from Henry de Bracton's 13th century treatise that says, if a person has, quote, struck a pregnant woman or has given her poison whereby he has caused an abortion, if the fetus is already formed and animated, and particularly if it be animated, he commits homicide. So implicit here is the idea that murder statutes can apply to abortion, the abortion context, which is something the Supreme Court has never held, and is a highly contested issue for a range of reasons. But the idea that we would look to 13th century treatises to decide what ordered liberty means today is to lock our notion of what it is to live under a constitution in a constitutional democracy in terms that are recognizable to writers of treatises at that time in the 13th century. So he then goes through more and more legal history from largely from the UK, but not only, to make the conclusion that it is the inescapable conclusion that the right to abortion is not rooted in our nation's history. Therefore,
it can't be found in the Constitution now. This is something that the court just made up in Roe versus Wade. Now, it's important that this is a moment when Justice Kennedy, who retired from the court early and in a way enabled this 5-member conservative majority and is still alive and functioning quite well, should be quite uncomfortable. Because in Lawrence versus Texas, 2013 decision that said it was unconstitutional to criminalize sodomy or same-sex sex, he looked at this Glucksberg case and this idea of substantive due process being something that it kind of animates the history and traditions of ordered liberty. And he said moral disapproval of a class of people like gay people or particular conduct like sex or abortion is never a legitimate state interest. In Lawrence, the very reasoning that Justice Alito is using in this draft opinion was repudiated by Justice Kennedy and a majority of the court. So what Alito is doing in writing this draft opinion is erasing the jurisprudential legacy of Anthony Kennedy. He's doing it time and time again in this opinion. And it's you know, over and over as I've been thinking about this draft opinion, I thought, well, what must Justice Kennedy be thinking in seeing in one opinion his entire legal legacy unraveled? So substantive due process for the most part doesn't exist anymore, certainly doesn't exist in the same way. Then he also says bans on abortion are not forms of sex discrimination. It's kind of a little side argument. The legislators in these states, whether it's Mississippi or Texas, who voted in favor of these statutes, they don't hate women. They care about fetuses, right? That's not sex discrimination. And prohibitions on abortion never amount to discrimination against women. And this is specifically an argument addressing Justice Ginsburg's primary position on why access to abortion was such a fundamentally important right for women. Her argument had always been that without the capacity to control our reproductive lives, women will never be able to be equal in the workplace, in politics, and in our lives more generally. In that sense, access to abortion was instrumental to women's full citizenship, right? And Alito answers her, not only by saying banning abortion is not sexism, but he also makes a kind of weirdly feminist argument and says, actually, women are much more equal today than they were in 1973, so they probably don't need access to abortion anymore. They are equal citizens. This, as I read that, it reminded me of the dissent of Justice Ginsburg filed in Shelby County versus Holder, a voting rights case where the Supreme Court, by a majority, basically gutted the Voting Rights Act because, heck, we don't need it anymore. That racism of the past, we don't need it anymore, so the Voting Rights Act isn't doing any more work. What Justice Ginsburg said in her dissent is that throwing away pre-clearance of having to vet these restrictions on voting through the Justice Department, when it has worked and is continuing to work and is stopping discrimination in voting, is like throwing away your umbrella in a rainstorm because you're not getting wet. It's just a fabulous analogy. I think it applied in the voting rights context and it applies here. Like, let's get rid of the right to abortion because women are equal. Well, part of why women are equal is because we have access to abortion, or at least some of us do. I have so much more to say about this, but I want to take your questions. So the last thing I just want to note is that if the court were scanning the canon for cases that were egregiously decided or egregiously wrong at the moment they were decided, I would not nominate Roe. I would nominate Buck versus Bell, a 1927 decision by Oliver Wendell Holmes, in which there was a lawsuit was brought by a woman who was forcibly sterilized on the theory that she had, and she was in a mental institution, on the theory that she should not be able to have more children because of her mental disabilities. And Justice Holmes upheld her sterilization, saying, and I'm quoting here, 3 generations of imbeciles is enough. It just so happens that Carrie Buck did not have a mental disability. She had been raped as a teenager by a relative, became pregnant, and was put into a mental institution because of the shame of her being a young pregnant girl. She had no mental impairment. I also don't think that people with mental impairments or disabilities should be forcibly sterilized either. But those were not the facts in this case. So if we were to find, and this was during a period of strong eugenics, of which Oliver Wendell Holmes was part of that movement as well. If we were searching for a case where we would, by today's light, say it was egregiously decided, Buck versus Bell leaps to mind as one of the most obvious ones that we might start with. So why don't I pause there and just take some questions. And Kambiz, do you want me to read the questions, or do you want to field them and read them for me?
Hi, I can jump in here. I'm just going to start my video in a second.
Okay.
My name is Miyako. I'm the admin for the Columbia Alumni Club for DC. Okay, my video is not starting yet, but I can read them to you. Oh, here we go. All right, hello.
Really?
Great. Okay, so we do have a bunch of questions coming in. Just as a reminder to everybody on the line, if you have any questions, please put them into the Q&A box, not the chat. So put them in the Q&A and we can get to them now. We have most of an hour. So I'll just go ahead and start from the top when questions started coming in. So Dr. Lawrence Haynes asks, what other SCOTUS leaks have occurred?
Several, I would say half a dozen opinions have leaked, but probably most notably, the decision in Roe versus Wade was leaked the day before it was issued. It was not the actual opinion, but it was how it was going to come out, and some of the deliberations of the justices, and that caused uproar in the court, to be sure, but there was such a short time between when that leak happened and when the final opinion was issued, and there was no difference between that opinion and what the final opinion was, that I think it distinguishes itself as quite different from the circumstance we're looking at now.
So somebody asks if there is a racial element driving the zeal of the opponents in Roe versus Wade, and if you have any statistics that you could share on this.
You know, women of color have always argued that they had a particularly compelling need for the full range of reproductive health care. In this country right now, overwhelmingly it is Black women who seek abortions, legal abortions. And part of that is, and particularly in Mississippi, which the Dobbs case is about, and part of that is because of such terrible education, sex education in schools or otherwise. Access to contraception is much lower for low-income women of color than for more affluent white women, and a whole host of other reasons. And so there certainly are, and I would say that Black women, Black and brown women, are 3 to 4 more times more likely to die in childbirth than are white women. And so abortion is a particularly important life-saving medical treatment, healthcare treatment for all pregnant people, but particularly for Black and brown women. And the inability to obtain an abortion for many Black women will be a death sentence. Now, Roe wasn't really framed that way in the 1970s. It was the lawsuit itself, and much of the reproductive rights movement, as was the feminist movement at that time, was largely white-led and led by affluent white women. But that isn't to say that there wasn't organizing in communities of color around this issue. The person who asked the question, though, I'm not sure, maybe was referencing Justice Thomas, Clarence Thomas, who is Catholic himself, both personally and professionally as a justice and a jurist, opposes the right to abortion. And he has made the argument most clearly on the Supreme Court that abortion is a form of eugenics towards Black women because it's so many Black women who have abortions. And for that reason, abortion should be rendered illegal or criminalized because it is the killing of future generations of Black children. We could debate why that's the conclusion from the data that more overwhelmingly Black women are the ones having abortions, and that banning abortion might not be the best way to deal with that problem. But Justice Thomas has very much aligned himself with that view. And indeed, the most recent opinion he's written from several years ago, not too long ago, in which he made that argument, he actually cites Buck versus Bell as good law, which is quite shocking. So next question.
Next. So somebody asked if you think that this will open the floodgate of other federal regulations, and they mentioned OSHA, to be moved down to the state legislature level.
Well, OSHA is the Occupational Safety and Health Act. That has to do with workplace safety. Are you being forced to breathe toxic substances in the workplace? If you're working on a construction site, do you have the safety materials that you need, say, to climb on top of a tall building and stuff? I imagine there could be an OSHA component to this, but more what we've seen on the federal level is the banning of federal funding for any kind of abortions through Medicaid or otherwise, at both domestically and internationally. And indeed, there are components of, or at least there used to be components of our, from the State Department in any kind of foreign aid that would go to groups that they would have to sign a pledge that they would not support abortion or use any of that money for abortion related either practices or advocacy. But many people are now urging the Biden administration to issue regulations that would allow access to medical abortions or drug-based abortions that you can do at home, and to preempt the field, essentially, to say that states can't regulate in this area. And there's plenty of evidence from many, many other drugs that it makes sense to have a national standard around health and safety having to do with drugs, not state by state standards, and that the US government could do that now around access to basically the abortion pills. And we'll see if the Biden administration is willing to do that. But I think most of the action is going to take place on a state level, not so much on a federal level.
And so if states do kind of get to that point where they have different laws on the books across state lines, we have a couple of people asking what you think will happen to both the people that cross state lines to get an abortion. Somebody says, are we going to go back to the Dred Scott days? Somebody else asks what you think SCOTUS will rule on if the law banning women crossing state lines for abortions, if they kind of rule on that.
We'll just have con law class here for a moment, constitutional law class for a moment. One right that the Supreme Court has recognized in the Constitution is the right to travel. And they've made that, they made that ruling many, many years ago that was largely related to political participation, that one would travel, say, to Washington or to your state capital to engage with your elected officials. And bans on travel affect political participation and the idea of a democratic form of government. But a kind of ban that would allow you not to travel out of state or to even travel within the state for the purposes of obtaining reproductive health care would clearly violate current constitutional law around a right to travel. We will see whether this court will affirm that right, because it's something that was, as I said, articulated in the kind of political participation context, and they might see access to healthcare as being a very different kind of thing. So we don't know there. But states are already
we have seen bills introduced in a range of states that would ban travel to another state to obtain reproductive health care. And enforcement will be challenging for states to know that that's what you're doing. And I'm seeing memes across the internet of anybody want to go camping, you know, wink, wink, in New Mexico or elsewhere. You know, crimes, anyway, these crimes are difficult to prove, but I think its deterrence effect is almost as important as what the actual enforcement will look like. But I would like to think that even this Supreme Court would not uphold the idea that one can't travel for the purposes of obtaining healthcare. You know, people come to New York City all the time to get their knees replaced at the hospital for special surgery, or you go to the Cleveland Clinic to get cancer treatment, or the Mayo Clinic to get treatment for something else. There are hospitals or medical professionals with expertise all over the country where people travel for medical care as a routine matter. And to exceptionalize abortion, I think would be kind of a tough lift to uphold that in the Supreme Court, but we'll see. We've got a very conservative federal judiciary and now a very conservative Supreme Court. So there's that, plus what we're seeing are bundles of bills being introduced in more progressive states like New York. There's a bill in Albany pending right now that would not allow for the extradition to another state of anybody who's providing abortion, or someone who came to New York in order to get an abortion, or somebody who facilitated coming to New York to get an abortion. And this is where I think, you know, you had mentioned Dred Scott. I think the parallels to the Fugitive Slave Act and to the ways in which Southern states tried to have their slavery laws have extraterritorial traction is undeniable. And Congress, in a way, collaborated with that effort on the part of the South to have their laws apply outside their states, but in states that were free states, by enacting the Fugitive Slave Act in 1850, right? That set up these commissions where people that you had an obligation to turn in a Black person who might be a fugitive from enslavement. And then these commissions would hold trials on whether that accused Black person had been enslaved, and the Black person could not have a lawyer and could not testify. This is another area of my work, is American racial history. And so I would hope that most Americans would be aghast at the thought that we are going to reproduce a form of the Fugitive Slave Act with these kinds of efforts to extraterritorialize abortion laws. It's bad enough that you're going to do it to your own people, but you know, we don't want that here. But we'll see what the court does. And this is an area of kind of untested constitutional law. So we'll see where the law has evolved when the federal courts start to interpret these new state statutes, sort of banning the reach of laws outside their own states.
All right, we have a ton of questions coming in, so I'm going to try and get to as many as we can. Tom asks why Europe has managed to successfully navigate the abortion issue without a case similar to Roe. And he says it appears to be a good example of complex issues being successfully settled via a purely political process. And then a little bit of alternative analysis here. Is it possible that would have been the outcome in the US if Roe was not decided the way that it was?
Well, that's a lot of questions, and maybe Tom is a better expert on European politics than I am. I don't profess to be an expert on European politics. I will say Europeans, for the most part, tend to be less religious than we are in the United States. I think we are much more religious and conservatively religious in the US than they are in Europe. And to that extent, I think abortion has been seen in many, though not all, European countries as an essential part of healthcare. They also have, or at least used to have, pretty robust universal access to healthcare in most European countries. And abortion was just kind of nested within that full spectrum of healthcare, reproductive and otherwise, that people got. The examples, though, that I think are really compelling are of Mexico and Colombia. They also have, or at least used to have, pretty robust universal access to healthcare in most European countries. And abortion was just kind of nested within that full spectrum of healthcare, reproductive and otherwise, that people got. The examples, though, that I think are really compelling are of Mexico and Colombia.
Catholic countries that have recently decriminalized abortion through their Supreme Courts or their state, parliaments, and are moving in the opposite direction from where the United States is going. And that I just find devastating. That we are, that, you know, we think of ourselves as the most evolved democracy on the planet, and the freest place on the planet, yet we're seeing examples in unlikely places where particularly women's equality and freedom are being secured in new and expansive ways while we are contracting those domains. So too, you know, on racial justice and other issues. But Tom, I'm not an expert in Europe, but it's a great question.
I do think that there's a lot of questions coming through kind of on how religion impacts a lot of these decisions. So somebody asks, you know, how can upholding and interpreting the Constitution with a religious premise for preventing abortion when all Americans are free and have a right to pursue other religions or no religion, which may rather uphold individual rights and agency over reproductive rights? Somebody else asked if somebody could, I'm trying to find the question, theoretically, like, could someone ask for an abortion based on their religious beliefs? So kind of how does it align?
Excellent question. So the bans on abortion pre-Roe, and then some of the ways in which abortion regulations have expanded after Roe and have not violated that undue burden standard under Casey, could be viewed as the government taking a religious position on when life begins, or a religious position on, you know, reproductive rights more generally, and that violates the Establishment Clause, right? The second half of the religion clauses in the First Amendment says that Congress shall make no law establishing a religion. Or as the courts interpreted it, favoring some religious views over others. And unfortunately, in the litigation that has lawsuits that have challenged those abortion laws as violating the Establishment Clause, we have lost them every time. The courts have said, caring about fetal life, protecting fetal life is not necessarily a religious value. I mean, it is in many cases, to be sure, but as intuitive as it seems to many people that what we're seeing is the embrace by government and now by the Supreme Court of a particular religious view of abortion, and that should violate the Establishment Clause, this court will never rule in favor of that argument, and even more liberal courts have not either, which is, I think, shocking for many people. Europeans, just to go back to Tom's question, Europeans find this to be outrageous. I mean, it looks from the outside absolutely like the government taking a religious position on abortion. With respect to the free exercise issues, this is something I am working on every day. I run the Law, Rights, and Religion project at Columbia Law School, and we have gotten involved in a number of cases where progressive people of faith have been prosecuted by the government for their humanitarian actions, such as people at the southern border in Arizona who leave out food and water for migrants who will die in the desert and do die in the desert without food and water. And they're doing this as part of their faith and their belief in the sacredness of human life. And that whatever our immigration laws say, we shouldn't let people die. And they've been prosecuted by the Trump administration for facilitating, the argument was, illegal immigration. And I worked with the criminal defense lawyers in that case, and we raised a religious liberty defense, and we won. Remarkably, we won. Same with, there were a bunch of Catholic workers who broke into a nuclear military base in Georgia, and they staged a mock trial of the nuclear weapons. They were prosecuted for breaking into that military base, a very serious, federal crime. We worked with them. They were priests and nuns to raise a religious liberty defense, and they lost. Others have used religion to religious liberty claims to try to address issues of environmental degradation,
harm reduction and drug use and a whole range of things. So religious liberty isn't something that only the right wing gets to use. People of whatever faith tradition, it should be neutral. And so we are planning, if I can say to this small intimate group, so don't tell anybody, those lawsuits are being teed up right now among people of faith who believe either as a matter of their own faith that they should have access to abortion, or providers who are people of faith who feel that providing abortion along with other reproductive health care is part of their ministry, or people who, as part of their religious beliefs, are assisting people in getting out of the state, or providing them housing, etc. And so you will see those lawsuits quite soon.
Great. So Lou asks if we can take just a bit of a step back and kind of look at the overall impact that the decision might have. So I know I've seen a chart, there's tons of memes and charts and all floating all over the internet, but like when Roe started, how many abortions there were, and then it went way up, and then and what I saw at least was that it fell down now to less than it was when Roe was enacted. So I guess Lou is asking, how many abortions were there in each of the last 3 years, or X years you want to talk about? And then what % of those were in states that have laws that would ban abortion? So how many people kind of will this affect if it goes into it?
I don't know. Off the top of my head, I can't tell you. I'm a lawyer. I'm not a demographer. There were excellent amicus briefs filed in the Dobbs case, and I would urge you to read them. There was one in particular written by the Howard Civil and Human Rights Clinic, looking at the racial implications of banning abortion in Mississippi, that is just outstanding, and I would commend everyone to that decision, or to that amicus brief. But I don't have that data off the top of my head. I think the important thing to recognize, just a second, my cat wants to become part of the webinar. The important thing to recognize is that Roe will not end abortions in the states that have criminalized it. It will merely end legal abortions. And pregnant people will continue to get abortions. They will be much less safe. People will die because of it. And there will, of course, be some people who will not get abortions who would have otherwise, because of the fear of criminal prosecution. But I think a lot of that data is probably unreliable, insofar as illegal abortions before Roe were not counted. So the number of legal abortions, of course, went up because they were now legal. But there were plenty of illegal abortions beforehand, but they were not being reported through, state health departments or, et cetera, in the same way that legal abortions would be. So I would take some of those numbers with a grain of salt.
Justin asks about kind of the way that the court evolves over time. So because there are 5 people and we have stare decisis where they're supposed to look back on decisions that have made in previous generations as precedent, as these new generations of courts come around, like how did they change with the time while they're supposed to follow stare decisis?
Well, let me say what's interesting. I mean, the court is very, very, very resistant to just flatly overruling prior decisions, because they don't want it to appear or be the case that what the court rules is just based on the political makeup of the court at a particular time. On the other hand, our sense of justice changes over time. So for instance, Plessy versus Ferguson, the case that said separating people on the basis of race, Jim Crow segregation, is constitutional, and there's no problem with that. And this is from the late 19th century. That's overruled 55 years later in Brown versus Board of Education. Bowers versus Hardwick is decided 1986, saying there's no constitutional problem with criminalizing sodomy. That's overruled by the Supreme Court in 2013 in Lawrence versus Texas. And Justice Alito points to both those cases as examples of where the court has said, no, those cases, the earlier cases, were egregiously wrong. What he doesn't say is both in Brown
and in Lawrence, the court didn't overrule the legal conclusion of the earlier cases. What the court said is, in Plessy and in Bowers, the court got their facts wrong. So in Plessy, the court says there's no constitutional problem with separating people on the basis of race. If Black people feel inferiority because of it, or feel inferior because of it, that's because they're choosing to take it that way, right? It's not intrinsic in the idea of racial segregation that one group is subordinating the other. They're just sensitive, right? And in Brown, the court says that's just wrong as a factual matter. And they use these doll studies, the Clark doll studies, where they had a Black doll and a white doll, and they showed these dolls to little kids, Black kids and white kids, and they said, which is the smarter doll and which is the prettier doll? And the Black kids always picked the white dolls. And they said, look, this sense of inferiority is intrinsic to the idea of racial segregation. So we're not changing what the Equal Protection Clause means. What we're saying is that the court's interpretation in Plessy was based on bad facts. Same thing in Lawrence and Bowers. I'm getting way into the weeds here in constitutional law. But in Lawrence, the court said, Bowers had the wrong facts about homosexuality. Let's correct the record on that. And based on those facts, this is how the case should come out. That's very different from saying the legal reasoning was abjectly wrong or egregiously wrong in a court's prior decision. They rarely ever do that. So citing these other cases is actually not quite right, because Justice Alito isn't saying that Roe had its facts wrong. Justice Alito is saying that Roe made up a constitutional right that doesn't exist.
We have a lot of questions, but we have a couple of questions that are coming through on Plan B and access to contraception. So how will some of those other, medications that women have access to now, will that be affected as well by this case?
Well, a lot of people are saying, oh gosh, if this draft opinion becomes the final opinion, or some version of it does, what will happen to same-sex marriage? What will happen to abortion? What will happen to privacy rights? What will happen to even Loving versus Virginia, the Supreme Court's decision that said that Virginia's miscegenation law, or law that criminalized white people from said they couldn't marry non-white people. So laws criminalizing interracial marriage. What about that? And Justice Alito says, in this decision, we're not deciding those things. So don't get all worried about it. We're only deciding the abortion thing because the abortion thing is special. It's about human life. And he does refer to the fetus as a child many times, and human life, in a way that we've never seen the Supreme Court do. But to be honest, the way in which Justice Alito kicks the legal legs out from under Roe leaves nothing for Obergefell or the contraception cases or Loving versus Virginia to stand on, right? So while they're not deciding those cases now, it's a little hard to see what is left of those decisions. And certainly Justice Kennedy's reasoning in a bunch of those contraception, same-sex marriage, even laws criminalizing sodomy, they were found unconstitutional for reasons that also rested on, Roe rested on. So we'll see.
There have been a couple of questions that came through regarding slavery. So one person asks about, how this can relate to the 13th Amendment. Somebody else asks if forced pregnancy can be seen as a form of slavery.
Absolutely. There are advocates who have made that argument for years, that forced pregnancy violates the 13th Amendment as a form of slavery or involuntary servitude. And it's not an argument that has ever really gotten any traction in the courts. I think people felt like they didn't need to make that kind of radical, innovative, creative argument because we had Roe,
its kind of rational way of thinking about trimesters and the medicalization of the right, and analogizing it to slavery is kind of a big leap. But on the sort of public opinion level and on the way to message what's happening, many people have referred to denial of abortion rights as imposing a kind of slavery and forced compulsory pregnancy on pregnant people. Reva Siegel, who's one of the most prominent law professor scholar from Yale Law School, has been making that argument for a very long time. Akhil Amar has, and many other people are as well. I don't see this court going for that argument, but I think it has strong and really interesting rhetorical force.
And I definitely don't think you're getting too in the weeds for this crowd based on the questions that they're asking. So please go as you would like to.
I know the thing about these webinars is I'm just staring at myself and you, and
yeah.
I don't get to see all the other people, which is a drag, because I look forward to one day doing these things in person again.
Yes. Okay, a few more questions in our time remaining. Very specific question here. So who would have precedence if there is a federal law abolishing abortions while a state maintains that you can have one?
Hard to say. Hard to say. The Supreme Court just said states can criminalize abortion if they want to, and it's important that the states be given that kind of freedom. I think we could also say states could then take their own state-by-state position on same-sex marriage, on sodomy, on contraception, on a whole range of things. That certainly flows from this opinion. But if the federal government rules, or if there's a bill that was in the Senate today that failed, declaring Roe versus Wade a federal right. I didn't think it was a good idea to bring that up for a vote today, but I was not consulted. It would be an interesting question of what authority the Congress has to federalize an abortion right. And knowing what we know about the Supreme Court, they could very well say that the Congress does not have that authority, and that it is essentially something that should be left to each state to decide on its own about how to protect the welfare of its citizens, both born and unborn. I wouldn't use that term, born and unborn, but I could see the court using that term.
Okay, going back a while when this question came in, but somebody says, doesn't Bostick provide a strong precedent that could be applied to gay marriage without referring to right to privacy? Gorsuch wrote that one with Roberts concurring, and they say that they've always thought the original opinion needed another 300 to 400 pages of rights responsibilities that are reserved to couples who are married in addition to the swearing rhetoric. Still leaves contraception at risk though, especially since many people assert without evidence that some forms of contraception cause abortion.
Yeah. Well, Bostock was a win for LGBT equality, but it was a terrible opinion. I teach it every year, and it's impossible to teach. What we see in Bostock is Justice Gorsuch taking an extreme, I get choked up just talking about it, hold on. He engages in very technocratic reasoning that I actually didn't think that they would embrace this argument because it was argued by the ACLU in the case, but they did. That if an employee marries a person of a different sex, they would be celebrated at the workplace. But if the same employee married somebody of the same sex, they could be fired, and that amounts to sex discrimination because of the sex of the other person. If you just swap out an M for an F. So it's a very kind of technical, logical form of reasoning that doesn't get at the underlying question of, well, why do we have a norm against this? Like, what's wrong with discriminating against lesbians or gay men or transgender people? Instead, it asks you to play this little logic game. So Bostock gives us nothing to work with. It has no it can't be cashed out in future decisions unless you can play that little logic game. And abortion actually goes the other way. In Justice Scalia wrote in a case called Bray, B-R-A-Y, but also in Geduldig, which was an even earlier decision, the Supreme Court ruled that discrimination on the basis of pregnancy is not sex discrimination. It was an employer who required all pregnant employees they were no longer employable. You should stay at home. You couldn't be in the workplace. And the person brought a sex discrimination lawsuit, and the Supreme Court said that is not sex discrimination. It's discrimination against pregnancy, yes. But federal law doesn't prohibit discrimination against pregnancy, because it's not M versus F, it's pregnant people versus non-pregnant people. That's the differentiation here. And maybe pregnant people is all women, which even today we would contest, but the category of non-pregnant people is both men and women. So it's not a sex-based differentiation, it's a pregnancy-based differentiation. So this kind of logic game that we then see used again in Bostock, it's kind of formal reasoning, it's annoying, to be sure, but it also doesn't get at the underlying value of, why do people discriminate against people who are pregnant? It's usually sexism. And why do people discriminate against lesbians and gay men or transgender people? It's because they hate us. Right? It's because they're bigoted towards us. And it's because of what I would say a kind of value of heteropatriarchy. But we don't see any of that in the Bostock opinion. So it doesn't help us with same-sex marriage. It doesn't help us with abortion. It doesn't help us with contraception.
We did have Susan wrote in saying that in person is great, but this format means that a lot more people can participate. So she says, don't give up. She likes
right. That's right.
I will say we definitely get people who write to me and say, oh no, I'm in New York, or I'm going to be in France that week. Can I still, watch it? So we have people who watch it after the fact. So thank you again. Okay, so we have a question about the argument around abortion for self-defense. So some people, if they have been raped or she's been made pregnant against her will, that the fetus will not have a normal life. Normal is in quotes here, in very loaded term, they note. So how will this apply? I'm not sure if you mentioned this, but if this case goes through as written, how will self-defense and those kind of things, or rape or incest, how will that play into?
Some of the states are passing laws criminalizing abortion, except in the cases of rape and incest, and sometimes they also include the health of the parent, the pregnant person, and some of them are not. Some of them are passing complete bans on abortion, regardless of how the person got pregnant, the way that the court ruled in Alito is that that's up to states to decide how to protect fetal life. And as we saw Justice Barrett say in the oral argument on last December 1st, in this case, the problem of an unwanted pregnancy or compelled pregnancy, in the case of rape or incest, is solved by these laws that allow you to leave your infant at a firehouse or a police station or a hospital. And other people can then, who want to raise a child, can raise that child. And she herself has done this, adopting 2 children and having also biological children of her own. I think a lot of us were kind of surprised that she felt that solved the issue of not being able to have an abortion, both for the born infant and it growing up knowing that it had been left at a firehouse or a police station, but also for the pregnant person. Giving away the child doesn't cure the problem of a forced pregnancy or being forced to be a parent when you did not want to be. You don't just leave your identity in your mind and your heart. But that was Justice Barrett's position.
And so if this goes through, states have different rules, laws in effect. Somebody asked if there are companies in some states that in conservative states that pay for the cost of an abortion for one of their employees, would they be held liable in the state given the conservative laws?
They could, because some of these laws are broad enough. The Texas SB 8 bill, and then some of the other bills that have been passed in other states, criminalize facilitation of an abortion, whether that's driving someone to a place where they could get an abortion, giving them housing, giving them money, even giving them information about any of that. So an employer that would include in their health plan abortion in a state that criminalizes abortion would probably be committing a crime in that state.
Okay, going back to when we were talking about the 13th Amendment grounding, Katherine says, can't the forced pregnancy argument be grounded in equal protection and then not need to meet the more radical 13th Amendment grounding? Part and parcel of equality and freedom for Blacks was the right to do with our bodies what we want. Good intersectional approach for litigation and political approaches. Excellent question.
There are many people who have, from the very beginning, believed that access to the full range of reproductive health care is essential as an equality right. And Justice Alito said no, that's not the case in this draft opinion, but that doesn't mean we're not still arguing it. As I mentioned before, Justice Ginsburg saw the equality argument as kind of instrumental, meaning access to reproductive health care was necessary to equality in other places. But your questioner makes an even, I think, more principled argument that the regulation of our reproductive bodies is itself is an essential affront to equality, to our capacity to control our bodies and make decisions about our bodies on a level that is equal to how, let's say, men are. One of the other things I do at Columbia is I run a project on the Equal Rights Amendment. And there are several states that have passed their own state equal rights amendment while we're waiting for the federal government to lift a deadline that would that's denying the ERA from entering the federal constitution. And there's a case just on this issue before the Pennsylvania Supreme Court right now. Pennsylvania has an ERA. Pennsylvania also bans Medicaid funding for abortion. And the Women's Rights Project in Philadelphia has filed a lawsuit saying that denying access to abortion for poor women violates Pennsylvania's Equal Rights Amendment. And we wrote an amicus brief in that case, laying out for the court all the different reasons for why limits on access to abortion are a violation of equal protection. So if you're interested in that, please go to the ERA Project's website and you can download that, both the brief, but also we have a little 2-page FAQ on abortion and equality that someday, hopefully, the Supreme Court would embrace.
Okay, Arthur says when he was a medical student, when abortion was completely illegal, and one of his professors advised a diagnostic D&C in case of rape, and asks if that would work today.
Well, yeah, there are all sorts of ways in which medical professionals have, from the beginning of time, worked around laws that criminalize abortion by saying this procedure is justified for other reasons, or this procedure actually isn't an abortion. It does end up terminating the pregnancy, but they wouldn't call it an abortion. It's really up to what the local prosecutor feels in terms of whether that practice is something that violates the local law, and where you have sort of an evangelizing, if you will, prosecutor or police who really are adamant and quite aggressive about enforcing these laws. I think that doctor would be in a pretty precarious place. One thing I will note is that we issued a report a few months ago on Southern hospitals. It took us 2.5 years to study Southern hospitals that had religious affiliations, because we were interested in seeing how their religious affiliation, usually Protestant, not Catholic, but Protestant affiliation, Baptist, Methodist, et cetera, impacted access to reproductive health care.
And we found that it did enormously. But even more shockingly, we found that secular hospitals, whether they were public hospitals or university hospitals, also had great limits and religiously based limits on access to abortion, not because of their religious affiliation, but because of the communities in which they were working, they were located, were so religious and opposed to abortion that they didn't feel that they could provide it to their patients and survive as an institution in the community, or whoever was the head of obstetrics, himself or herself, didn't believe that abortion was moral or should be legal, and basically let everyone know we're not doing abortions here. So, what I started by saying that Roe has been overruled for many, many people in this country already for years. That is certainly the case in religious hospitals.
Well, we have just a couple of minutes left, so we usually end by asking if there are any books or podcasts or people to follow if people want to follow this issue more, especially as the coming months happen and the decision goes through. What can we do to stay informed?
Oh gosh, well, as I said, Nina Totenberg's piece in the Daily I thought was excellent on sort of what the landscape looked like pre-Roe. Dahlia Lithwick's podcast I think is fantastic. So is Melissa Murray's and her other two cohorts that are doing a podcast. I think they're excellent. It's called I think it's called Amicus. And then Linda Greenhouse is wonderful. She's, used to be the legal reporter for the New York Times. She's since retired, and Adam Liptak has that beat, but she still writes op-eds for the Times quite frequently. And she knows the abortion issue inside and out and is just very responsible and careful in her reporting. I would read all that work. And then of course, I'll send you to our website, both the Law, Rights, and Religion Project, if you're interested in the religious liberty components here and whether progressive people of faith could mobilize religious liberty to try to protect some rights to abortion. And then our ERA project is working very closely on this issue to mobilize a framing of abortion rights as an equality right. There will be a vote probably next week on the ERA in the Senate. We will get more than a majority. Probably 52 or 53 senators will vote in favor of moving the ERA into the Constitution, but it's not enough to overcome the filibuster. I have an op-ed that just came out in The Hill yesterday that argues that the way we ought to spin losing the filibuster is that we've won. Right, we have more than we need in terms of a bipartisan majority of senators voting in favor of the Equal Rights Amendment, and that should be all we need to recognize that it is now part of the Constitution. And if we're amending the Constitution right now to add the ERA, it absolutely should include abortion rights. And so to the extent that Justice Alito and Justice Gorsuch and Justice Kavanaugh, et cetera, are saying there's no textual grounding for sex-based equality or for abortion, we've got the ERA that gives us sex equality language, explicit language in the Constitution, and we should use it. So watch that space, the ERA space, also for changes and advances in protecting abortion rights through the idea of equality. It portends to be actually quite productive.
Well, in our last minute or two here, I just want to say thank you again so much for being with us. I know we had a bunch of questions come in. We didn't quite get to all of them. But really great engagement from everyone. We did record the event and we'll be sending it out tomorrow. So if you want to send us any of those links that you mentioned, we can send them out to all of the attendees as well. And any closing thoughts?
I just want to thank you all for spending a lovely evening with me talking about this decision or this draft decision. It's been, for me, a tough week to be an American. To live in a country that not only will say that there's no constitutional right to abortion, but to do so in such an egregious way that basically writes women out of the Constitution. the opinion goes so much farther than it needs to overrule Roe versus Wade, and it does so in a way that is mean and vindictive. And I don't expect that from our highest court. So let's hope we see something that's a little less of all those things. But thank you all. It's lovely to be with other Yaleys. And I really appreciate the invitation to come back and talk to you. I look forward to doing it again.
Right. Thank you so much and have a great night, everyone.
Take care.